Well, welcome. This is Gary Wickert, and this is a momentous occasion with our firm, Matthiesen, Wickert Lehrer. This is actually the first mass webinar that we are going to do in a series of webinars on subrogation and insurance litigation-related topics. I have done this for 27 years. And I got to say, this is the one I'm most apprehensive about, and I've done it in front of as many as 1,600 people and as few as 4. We have a good audience today. This one makes me a little nervous because I have to rely on technology. And given the years I've practiced, you can tell I started practicing with IBM Selectric typewriters. So I'm used to the old school. But we're going to go forward. We have 472 attendees this morning. We're showing that 5 companies are presenting in conference rooms, so they have untold number of other folks. So it's a very good turnout. And I think the turnout is illustrative of something that we all have in common, and that is subrogation and the importance of subrogation, and most importantly, the significance of subrogation education. I'm going to go through real quick here some of the webinar interface housekeeping rules. And I think you'll see on your screen now a GoToWebinar attendee interface. This is actually has 2 different screens. It shows a GoToWebinar viewer window, and this is where the attendees, that's you, see my screen. The viewer window can be resized by clicking and dragging the lower right-hand corner, and the control panel, which is to the right, is where you, the attendees, interact with me, the presenter, and the organizers. And I'll go through some of that here real quick. First of all, if you click on the Grab tab arrows up in your screen, you can make this go in and out. You can enlarge it, and you can minimize the control panel. And the audio pane here, which I've indicated where it says use mic and speakers, gives you, the attendee, a choice. You have 2 options. You can join via audio through your computers using mic and speakers, or, and if you do that, you have to go into the audio setup to select your computer speakers or headset devices. Hopefully, a lot of you have got this down pat. Or you can use the telephone. And in this case, you select use telephone. You dial the number that's listed. You use both the access code and the audio pin when prompted when you call in. It's really pretty simple. It's like a conference call. If you're listening to me, obviously things are working. If you're not, you can raise your hand down here where it says questions. What we're going to do today, due to the large number of people we have, is we're going to hold questions until the end, or I'm going to give you another option. I'll talk about that in a minute. We did something similar to this in the test run with a lot fewer people, and the comments we got were that the questions sort of muddled up and muddied the presentation, and I don't want that to happen today. So we're going to have questions at the end, and I'll give you another option in a minute. All you have to do is type in your question and click send, or we can wait till the end of the presentation to do a Q&A session. I'll answer as many questions as we have time for. You can also raise your hand, and Jamie Breen, who is my secretary and working as a webinar assistant today, will do her best to answer those questions or funnel them to someone who can answer them, or we'll get to them at the end. If you prefer to keep your control panel open during the presentation, you can click View in the top menu up here, and you can pull down the pull-down menu and uncheck Auto Hide the Control Panel right there. So that's a basic run-through of how the webinar is going to be operated and your controls from your end. In future webinars, and I'll tell you about those in a minute, we're going to probably invite some questions because some of the future webinars may not be as large and may be more dealing with a specific topic. Now, as we get into introduction to workers' compensation subrogation, just a few introductory comments. It's clear from the picture on the front page that I did not pick out the graphics here. That's my secretary who did that. I would have obviously picked something from the Sports Illustrated swimsuit calendar, but I was outvoted. So ladies, there you go. We have today a great presentation, and we're going to be talking about some basics having to do with workers' compensation subrogation. As you'll see, this is going to be a survey or a skimming of the surface of a number of different subjects that we also will be presenting seminars over the coming months. Our goal at this time is to present a seminar every 60 days or thereabouts, give and take trials calendars. Different attorneys here will be presenting on different subjects, from property to health, surety, fidelity bonds, workers' compensation, auto. We're going to run the gamut. Why webinars? As I said, I've been doing this for 27 years. I've appeared at just about every conference, insurance convention that there is. And the one comment I've heard is that, especially in these economic times, it is difficult and expensive to send folks from your insurance companies all over the country for simple subrogation education. NASP, the National Association of Subrogation Professionals, of which I was on the board at one time, is a great organization and has done a good job of bringing regional and local NASP chapters. But I think in today's technology, this is going to offer the best opportunity for us to get education on subrogation directly to you. And what's nice about this is and you can tell your colleagues, if somebody can't make it today, if somebody is missing this presentation, if someone has to leave because of a cat claim that comes in or whatever, this webinar will be archived and will be available on our website for replaying. Everything you see today and everything you hear today will be replayable, so you can do that for people who weren't able to attend. Assuming it's good, you may want to tell them to avoid it. Speaking of which, when the seminar is done, there's going to be a survey. I hate surveys. I never fill them out. Now I know why they're asked. It's very important for us in future webinars to have your feedback, what you like, what you don't like, some of the problems you experienced, some of the issues you wished we would have gone into, and some of the things we went into that you wished we wouldn't have gone into. All of that helps us provide a better product next time. Our next webinar, just for your information, will be on Thursday, April 22nd at 10 o'clock a.m. The topic will be property subrogation, recognition, and investigation. And as the title implies, it's going to cover everything, the entire gamut from investigation to experts to fire to cause and origin, and how to effectively maximize your subrogation recoveries. I'm going to also invite you to, and I'm going to try my first technology move here, I'm going to also invite you to take a look at, and I'd like to give you a quick tour of the website for a specific reason, because I don't want you to feel that you necessarily have to wait 60 days. If there is a topic that you, and many of you are clients, some of you are friends, some of you are future clients, we hope. But if you have any interest in future seminars or webinars, it's super easy and convenient. For the last 27 years, I've had to get on a jet and fly to Florida or California, or I've given conferences and spoke at sessions in Austria, Moscow, London, and it is ungodly expensive. This is simple, it's easy, and it's recordable. So I think this is just a fantastic technology. And if you're looking at the home page, if you don't or can't stick around because you are hungry at noon when this webinar ends, and we do plan to go straight through, we have a lot of areas to cover. And the nice thing about this is if you have to get up, if you have to walk away and go to the bathroom or get a sandwich or whatever, you can do it. You'll obviously miss valuable information, but I'm just kidding. But you can do that, so we're going to go straight through without a break. On the home page of the website, over here is where the next webinar, and I'm not sure if you can see that, but I'm going to use something here. Over here is where you will see the next webinar advertised. And what we're going to do there is post it probably within the next week, so you can actually pre-register, and you'll be getting your invitation by the mail. If you are in this webinar, you will also be getting an invitation to the next webinars, or you can contact Jamie with regard to specific requests that you may have. If you have to leave at noon, as I said, you can scroll down here to the subrogation questions area of the website and submit your subrogation question, and it will probably get answered within 24 hours. Those of you who know our website know that this is a good tool, but specifically with regard to using it as an interface with this webinar, you can send your subrogation questions via that tool. Now, I want to also show you that during this webinar, I'm going to be referring to articles. When I get into a subject that's a little complex, and some of you are hungry for more information, I'll be talking about interventions in California, future credit hurdles that have to be made out there for employer negligence, or tactics that can be used in Florida or the ungodly state of Georgia. When I do that and I refer to a specific article, I will give you the name of the article, and here's how you find it. Just scroll down to newsletters and articles and click on either newsletters or published articles. I will tell you which. You click on it, and up come all the articles. If you want to search real quick, for example, I will be referring to a California article later. You can just go to Find. You can type in California, go to Next, and of course it says not found, but it is, you'll find, oh, I know, because it's in a newsletter, not in an article. You go to Edit, to Find, California, and up it pops, The Changing Face of Made Whole in California, and there are some other articles. So I will be referring to articles in that fashion. Now, getting back to the webinar. Introduction to Workers' Compensation Subrogation. Nothing is more important in understanding workers' compensation than understanding where it came from. It may seem a little pedantic, but it's ever so important, not only because we want to understand how we got workers' compensation and what it means to us, what its purposes are, but also because we are under assault right now. Those of you who know our firm and know me, I've been an advocate for a long time for subrogation. We've testified in front of the legislatures of 6 or 7 different states, been active with NASP in working on their societal benefits of subrogation presentations and their task force. I served on the amicus committee and have written the amicus curiae briefs for a good half a dozen significant subrogation issues that have come up. So it is important for us to protect the valuable asset of workers' compensation subrogation and subrogation in general. One of the most important ways you can help do that is to be aggressive and responsible in your subrogation at your offices and at your desks and for your companies, whether you be an insurance company or a third-party adjusting firm or a vendor or what have you. So the history of workers' compensation subrogation, and by the way, today's handouts, if you didn't get a handout, Jamie Breen will get you a handout. You can email her, and she can email it directly to you. We have a couple of handouts that are quite good. One is called Introduction to Workers' Compensation Subrogation. It's a condensed version of several chapters in our book, Workers' Compensation Subrogation in All 50 States. It's 26 pages long with authorities. And we also have provided a chart, Workers' Compensation Subrogation in All 50 States, which is a bold effort to summarize the law in an area that is very complicated and covers the gamut of 50 different states, as we'll talk about. Long ago, workers' compensation originated in Germany in the early 19th century. It had roots in socialism, and what happened is over the years with the immigration into the United States from Germany and some of the Central European countries, workers began to realize that they were being injured on the job and didn't have much recourse. If it was their fault, if they picked something up heavy and hurt their back or dropped something on their feet or stuck their hand into some sort of a press, it was their tough luck. But something else was happening. Around the early 20th century, we had the Industrial Revolution, and workers' rights began to come to the forefront. Injured workers whose lives were devastated began to appeal for something to be done, and eventually the employers began to agree with them because they were now being sued. A worker could sue their employer and recover tort damages simply because he was injured on the job if the employer was in the slightest bit negligent. That didn't sit well with the lobby at the time, and we had railroads who led the way. This was around the time when FELA was enacted. And so what they did is they lobbied to enact some sort of legislation that would protect the workers and protect the employers. New York tried some workers' compensation, but it didn't last. It was struck down in the courts. Wyoming tried. And Wisconsin, of all places, was the first state to enact workers' compensation legislation in 1911. Now, what was happening in Wisconsin in 1911? Well, we had fighting Bob La Follette as our governor. Eugene Debs was the socialist mayor of Milwaukee. We had a progressive movement here. This was the era of Teddy Roosevelt. And progressivism at the time was very, very pro-worker. So we enacted legislation which simply said this: if you are an injured worker on the job, no matter whose fault it is, we are going to force your employer to pay for your medical, no matter how much it is, for your lost wages, a certain percentage, no matter how much it is, until you reach maximum medical improvement. And that is going to be our way of society's way of protecting you. In exchange, we are not going to let you sue the employer. And that was the social bargain that was made, the social pact, that employers couldn't be sued and employees could have recourse only against their employer to recover workers' compensation benefits. All fine and well. The worker could still sue any other third-party tortfeasor, as we can today, if they were responsible for causing the accident, if they failed to prevent a premises defect from causing the injury, if they manufactured a defective product. All of this we'll talk about today. And that worked well until about 1917, when workers' compensation insurance and the employers began to realize that the employees were double dipping. They were recovering the once from the workers' compensation claim and recovering quite well, and recovering a second time in the tort case. So right around that time, the business lobby said, look, we need to have some subrogation rights as part of this three-way social bargain between the employer, the employee, and the workers' compensation carrier. And workers' compensation subrogation was enacted starting in about 1917. States dribbled in here and there until about the 1950s. But today, every state in the country allows for workers' compensation subrogation in one form or another. As we'll find out, they're all very, very different. But that subrogation lasted well until about the mid-1970s, when another lobby group got involved, and that was the trial lawyers, because the trial lawyers now were realizing that they were working hard, making great third-party recoveries against automakers, negligent drivers, product manufacturers, and when they got the money in, who was standing there with their hand out but you, the insurance industry, waiting for their workers' compensation subrogation reimbursement? That didn't sit well with them, so they then began to demand that legislation be passed which allowed them to recover a fee off of your workers' compensation lien. That was enacted in 1973 and following, and that worked well until probably the mid-'80s, at which time the trial lawyers also brought in a lot of other ramifications to the workers' compensation statutes, which we'll talk about in a bit. So the purpose of workers' compensation generally is to provide employees injured or killed in the course and scope of employment, fixed and certain monetary benefits, and to protect the employers from lawsuits by employees. This is the social bargain we made. But what the problem is that we are forgetting that social bargain. I'm going to lobby a little bit during this presentation, because there are some states, some judges, and some legislators that do not understand the aspects of the social bargain. Subrogation to them is a windfall to the insurance industry. And they're forgetting that it's you, the insurance company, that is on the hook through no fault of your own for millions of dollars potentially in workers' compensation subrogation benefits. So that social bargain is something I'll talk about throughout the seminar. Now, workers' compensation subrogation, again, allows the carrier to recoup monies paid to or on behalf of an injured employee when a third party is responsible. Duh. We know this. We also know that workers' compensation subrogation rights, your right to recover your money back, medical, indemnity, death benefits, And guess what? In some cases, adjusting fees, nurse care, case management. There's an article, as I mentioned earlier, there's an article on our website that has to do with when you can recover benefits other than the typical benefits. California and some other states allow for recovery of nurse care management and things of that nature. So many of my clients sometimes think that all they can recover for is medical and indemnity benefits, and that's often the case, but often it isn't. So workers' compensation subrogation is entirely dependent on state law. It's created solely by statute, and its purpose is to prevent a double recovery and to place the ultimate burden on the tortfeasor rather than the innocent employer or the carrier. Now, we have two states in particular who seem to forget this rule. There's Illinois and Minnesota. Both of these states allow a third-party claim for contribution to be filed against the employer by the defendants if they think the employer was at fault. I will talk briefly about how that's handled in those states when we get to those states. California and a lot of other states also now, Texas, which used to be just a bastion of conservative subrogation rights, is slowly being eaten away at, and now employer negligence is in play there. And in about half the states, some reference to employer negligence comes into play. I do want to say a word about your profession. I've been involved in this industry for a long time, as many of you have. It is no easy task by any stretch of the imagination to handle an area of the law that not only involves 50 different separate bodies of law, changing daily. And I know because we've got 3 published books, and every morning I'm bombarded with emails from a service I use that tells me what the current changes in the law are. And I would say once a week there is a significant change in the law. The book publishing industry isn't quick enough for me to react to that. I send my publisher the updates. They're updated online, but the book is only published once a year. So until then, we try to keep you updated on these changes in the law via our newsletter, which, if I'm not mistaken, and Jamie will correct me later, if you are attending this session and we have your email information, I think, via your registration, you will get that newsletter. If you don't want it, you can just respond that you don't want it. Now, workers' compensation subrogation is a strange animal. It provides absolutely the strongest subrogation right of any non-federal line of insurance, depending on the state. It gives you, the carrier, tremendous leverage even when your employer is negligent. So you can have an employer who is literally 90% at fault in causing an injury in most states, and you can still make a recovery, and all the defendants get to do is scream to the jury, hey, this was the employer's fault. If you find the employer solely negligent, you can check this box, but otherwise we get a full recovery against the 10% at-fault defendant. In this day and age, that is a tremendous advantage for us and your subrogation program to take advantage of, because it's out there. And one of the problems I see is a lot of our clients, when evaluating subrogation, and we'll talk about this in a minute, tend to too often look at, oh, what did the employer do wrong? What did the employee do wrong? And not enough on who outside of the employee-employer relationship contributed to causing this accident. We call ourselves, my firm and the 265 law firms around the country that we have contracted with to handle workers' compensation subrogation like to refer to ourselves as the terminators of subrogation, because, as in the movie, we never ever stop. I mean, if there is potential out there, we strive to find that potential. Obviously, there are cases in which we cannot find it, but one of the rules that I have is if you have a large loss, you have subrogation. That sounds counterintuitive, but if you think about it, it should reflect the inversely proportionate effort that you should put into detecting subrogation, especially in the larger cases. And investigation is key here, and we will talk about investigation in just a few moments. So, workers' compensation subrogation is deceptively simple. I would say the second biggest problem and mistake I see in subrogation programs is that after not recognizing subrogation, which we're going to help you do here, it leads to lax subrogation techniques and programs. What I mean by that is I often see large claims come to me just mere days or weeks before the statute runs, or after a plaintiff's attorney who had been friendly all along is now saying, well, no, I'm not going to pay you your lien because in this state there's a made-whole rule which we're going to apply, or a common fund rule, or your future credit and our fees on your future credit are going to wipe out your lien, or all the money is going to the wife for loss of consortium or to the kids or to someone else. I mean, there are new and creative ways that the plaintiff's lawyers try to prevent you from realizing your subrogation rights. And I want to tell you, I'm a member of the American Association for Justice, the AHA, which formerly was ATLA, the Association of Trial Lawyers of America. That makes me one of the enemies. I'm one of the bad guys. But what I always say is I'm a plaintiff's lawyer for the insurance industry. And I've been a member of the ATLA, and now it changed its name a few years ago to AHA, since 1980. And during that time, I've written prolifically for their magazine, Forum, on all sorts of topics. And I get, just like those of you who belong to NASP or other organizations and get on their listservs, I get their listserv emails daily with all the techniques and all the theories and all of the canned arguments that they should use to destroy your subrogation rights, not only in workers' compensation, but in health, in auto, in property, and other places. So because it's deceptively simple, I find some of my clients sort of default to what I call the found money myth. And that is that, well, there is some subrogation potential here, but surely someone's going to send us a check for this because, after all, there is a lien. And you know, even if we do recover only 40, 50, or 60% of our lien, still, that's a lot more than zero. And it's essentially found money. And I find that that attitude not only leads to poor practices within the industry in recognizing and aggressively pursuing subrogation, but it also is deleterious to our subrogation rights generally within the country. If one of our tactics is we work with trial lawyers, we get in there with them, we help them try their cases, many of them want us to, and if you are active, if you contribute in helping them pay for experts, you become an asset rather than a liability, and people will stop trying to destroy subrogation rights. We'll get into more of that, but what I want to mention here are some very simple 3 basic steps for improving workers' compensation within your program. As we go through this presentation today, we're going to focus on your job. You have to analyze hundreds of claims. One may not be discernible from the other, but the first one may have subrogation and the second one might not. You're going to deal with different loss facts, different states, different loss amounts, and 50 different bodies of law, each with changing and morphing complicated rules that aren't even discussed in their statutes, but are brought about through questionable court decisions. All of these are discussed in our book, which, by the way, I don't hawk books, and believe me, I wouldn't lower myself to hawking a book because I don't know what it is. It's either $20 or $22 we make on our books, whatever they are, so we don't make it for the profit, believe me. But what we do is we try to organize information and resources so that the industry as a whole can rally around one body of law and end some of the confusion. So we'll try today to give you the tools to maximize your subrogation recovery, and it starts with these 3 points. Early recognition of subrogation is the key. Those 4 words are the building block of everything we're going to talk about today. If you don't recognize subrogation, you will not have an opportunity to perfect subrogation. You will not have the ability to go after that subrogation, to put anybody on notice, to sit around and wait for someone to pay your lien, to engage local counsel, to engage a subrogation firm. You won't have any of that opportunity if you don't recognize subrogation. And it's important to realize that recognition of subrogation is not always easy. One of the seminars that we'll have coming up here fairly soon is, if you go to, and I will attempt to do this. Look how good I am. We're going to go to seminars and webinars on our website, and if you scroll down to Subrogation Basics, you're going to see that these have application to a lot of different areas, but the one I want to reference here is SU 101, Recognizing Subrogation Potential and Third-Party Liability. That is basically a first-year law school torts class condensed down into 2 hours. It's not easy for those of you who have defense background. You come from liability. You come from different areas within the insurance industry. We develop in our business a defense myopia. We see malingerers. We see fraud. We see people filing suits for things that should never, ever be filed. And we develop a jaundice. We develop a predisposition that most of the time accidents can be prevented, and usually the plaintiff is at fault. And that's only natural. And it's actually healthy if you're handling liability claims, adjusting those claims, resisting paying frivolous claims. But it is counterintuitive and counterproductive if you are have subrogation responsibility. And the problem is that while many of you have dedicated subro units and recovery units, and those of you who are with subrogation vendors, TPAs, this is all you do, that's fine. But some of you have to wear 2 hats. Those with programs wherein the claims adjusters have to recognize subrogation and then take off their claims adjusting hat and put on their subrogation hat after they've adjusted a claim, have to now think in a totally different direction. Is a product manufacturer responsible for this injury even though he stuck his hand where it shouldn't be? Is a product manufacturer responsible even though the employer removed a guard or removed a warning, or even though they violated the rules or didn't maintain the product properly? Is somebody at fault because they rear-ended a vehicle in front of them? We're going to get into this in a minute. Cases in which you go, well, obviously there's no subrogation here. There may be subrogation potential if you apply the tools that we will teach in the other seminar on recognition of subrogation and investigation. So once you recognize subrogation, and by the way, I want to mention too that it's against human nature for somebody, and I don't think there's anyone within the sound of my voice who's going to claim that they aren't busy at their jobs, and to be told that, okay, I'm busy, but I have to now double how busy I am, because in a claim which is straightforward, I now have to put people on notice. I now have to contact an expert. I now have to work with counsel. And a claim that looked like it was going to go away suddenly rears its ugly head in the form of a subrogation claim. So the inclination is to check no subrogation on a particular file. And that's where our firm and firms like us would like to offer our services to help you recognize that potential. If you go back to our website, and I think I mentioned, well, I did show you earlier, the question and answer form. You can send in a fact situation or a fact scenario, and we are happy to help you. There we go. We're happy to help you with analyzing facts. If you want to or need an expert for anything, we'll talk about this later too. We have a database of experts that I'll show you. But getting to number 2, prompt action on subrogation is almost as important as number 1, because in many cases we have state law, and I'll get into these in a moment. I'm not going to be able to talk about all 50 states, but I'm going to pick some select states that have some problems and some issues that may be traps and pitfalls for you. Depending on some states, your subrogation rights do not get any better from the moment you suspect that there may be subrogation to the day when you find out that somebody's trying to destroy them. Your subrogation claim has lost value. Now, there's a cost-benefit analysis that has to be gone into on every claim. Is it worth hiring subrogation counsel? Is it worth pursuing? Is it worth hiring an expert? But those are important decisions, and decisions that have to be made with the understanding that subrogation is an investment. It's the best investment we will ever see in our climate, our economic climate today, for sure. But pennies invested into subrogation potential can reap millions of dollars in benefits in the form of liens, and more importantly, as we'll talk about later, future credits. So prompt action on subrogation is necessary, as well as aggressive and cost-effective pursuit of subrogation, and that's where we come in to assist. Now, the workers' compensation analysis that I'd like you to consider for every claim you have is really very straightforward. You're going to ask yourself for every claim these 5 questions. If you answer these questions and answer them correctly, you will maximize your recovery in every claim. You will, in the process of answering these questions, accomplish the feat of determining whether or not it's cost-effective to pursue, who to pursue, and how much money you should be getting back. If under state law, say in Florida, you're entitled to $50,000 back on your lien, but you think you're entitled to $70,000 back, you're going to end up spending more money on that claim and reducing the cost effectiveness of recovering the $50,000 that you were only entitled to. So knowing your rights is extremely important. Who you can sue and when you can sue are important considerations. So the 5 points we're going to ask, and we're going to go through these 5 right now, using various state laws. What are your subrogation rights? Which third parties can be sued? How is a recovery allocated? Are attorney's fees or costs owed by you? Will they reduce your recovery? And do you get a future credit? You must know the answers to these questions to maximize your recovery. If you know the answer to 4 out of 5, I'm not saying this is approximate, but you may recover 4/5 of the value of your case. And the answers, of course, depend on which state you were in. So I have an article when it comes to pursuing subrogation rights. Do you hire counsel? Do you put people on notice and sit back and wait? Do you arbitrate? We have an article under published articles, again, you know where to go now, in a website calling Sweating the Small Stuff. And it details the pros and cons, the pitfalls, and the mechanics of actually going into special arb for subrogation rights. It's a very nuanced area because, of course, this is a strange area of the law where we have 3 parties. We have a plaintiff, we have an employer, and we have a comp carrier. And that plaintiff usually has a plaintiff's lawyer in tow. So that complicates it somewhat. But these are the questions that we have to ask. So let's look at number 1. What are your subrogation rights on any claim that may be on your desk today? Well, we have to answer certain questions. Who has authority to bring the third-party action? Is it the injured employee only? Is it a joint right of the employee or the carrier? Knowing whether you have the right to sue can make all the difference in the world. In Alabama, for example, there are specific laws that are different than those laws in Texas as to who has the authority to bring the action. If you look at the chart that was sent to you with the handout materials, in the 3rd column under Carrier Sue 3P, which is third party directly, you can see that in Alabama, yes, you can sue, and it tells you when. There are some states which allow the carrier to pursue claims on its own, and there are some that don't. Why would you want to pursue a claim on your own? If there is limited insurance on the other side, if the plaintiff's attorney gets in first, there are plenty of opportunities to gerrymander a case by allocating recovery to people who shouldn't have it. There are opportunities to claim attorney's fees, to reduce your recovery in a variety of ways, whereas if you had gotten in quickly and filed suit, that $25,000 policy limits could be yours. You want to know whether a carrier can intervene. Is it mandatory? Yes, there are some states in which you must intervene. Look on your chart under Arkansas. Intervention, must. You have to intervene or you lose your rights. In Wisconsin, we have the bizarre law of you are brought in as a necessary subrogated party under Section 803.3. When that happens, you must answer. You must file a subrogated cross-claim, or you will lose your rights. And otherwise, you'll be held in default. There are other states in which you must take action. There are some states in which you need not, but should. And then there are states in which you can't. We'll go into some of those. The next question is, when can a third-party action be brought? In Alabama, for example, you can bring a third-party action as the carrier 6 months after the statute of limitations has run. In Delaware, only after 260 days. In Florida, after 1 year. In Illinois, 3 months before the statute of limitations lapses. In Indiana, 1 year after the statute of limitation expires. Now, what does that mean? That means that, and I've seen clients all the time bringing me cases in Indiana saying, oh, guess what? I've got this great claim. The claimant didn't pursue it. I know that there's a 2-year statute of limitations in Indiana, and we're at 2 years and 8 months, so I guess we're out of luck. Well, no, you're not out of luck. You have a year after the statute to file suit, and it's a right that only you, as the workers' compensation carrier, have. In Rhode Island, you don't have a right to file separately. You have to know about those things. Are there notice requirements? Most states have some sort of notice requirements, some that work one way, plaintiff to you, some that work both ways. Are the carrier's rights lost if they're not protected in the lawsuit? You have to know the law that is governing the particular state you're in so you know what action to take. And oftentimes your answers to these questions will answer the very significant question of, do I get counsel involved? Some people hesitate to contact counsel and ask the dumb question, do I need to get counsel involved, with the understanding that I don't think lawyers are capable of saying, no, you do not need to get counsel involved. We pride ourselves here at being able to say that in the appropriate instances because it makes us look good and it saves our clients money. And that's what impresses them, not how many files we can handle for them. So knowing the answers to these questions are paramount. Now, looking at subrogation rights still, we're still on number 1. An example is in Wisconsin. If an employee is injured in a work-related accident in Wisconsin, let's take the following example. It's an automobile accident. The tortfeasor, let's say it's a driver who's negligent, is from Wisconsin. The injured employee is a Wisconsin resident. Wisconsin benefits are paid, and it's a Wisconsin employer. Pretty straightforward. Wisconsin law will apply. We're going to get into extraterritorial rights a little later. You don't need to remember them, but simply knowing that they exist in a situation where benefits are paid under one state and a third-party accident or a third-party lawsuit is filed in another state can save you a significant amount of money, especially when you're able to avoid the laws of bad states. So now, given these facts, let's look at the Wisconsin statute, Section 102.29. Again, our rights are given to us by statutes in the various states. Those statutes and the rights that are set forth in those statutes are augmented and sometimes changed and modified by court decisions. But 102.29 says the carrier or the worker may file suit. Each has an equal voice in the prosecution of the suit, unlike Florida, for example. Notice must be given to the other party, us to them to us, whoever files. The subrogated party must be made a party, that's us, it's mandatory. Either the employer or the carrier must bring the suit within the 3-year statute of limitations, no extensions. The carrier may intervene. The worker can intervene after the statute of limitations if we have filed suit. And it is probably the most favorable workers' compensation statute in the United States. Texas used to be, but after the recent tort reform down there and employer negligence getting in the way, Texas no longer has that title. Let's look at Alabama. In Alabama, Section 25.511 says that there is no simultaneous right to file suit between a carrier and an employee. The employee has the sole right, and as I said earlier, the carrier has 6 months after the statute of limitation runs to file suit. You cannot file suit before the statute of limitations runs. So I find myself in the awkward position of talking to third-party liability carriers saying, you know what, we don't want to settle this case with you just yet because the worker can come in and claim that he didn't get his share or that he wasn't made whole. But if you wait till after the statute of limitations runs, then we can settle it and the plaintiff can do nothing. And 9 times out of 10, they scratch their heads and go, okay, thinking that maybe they're going to get away without paying anything. The carrier may intervene into a third-party action almost always. Florida is an exception, unless it can make a substantial contribution to the suit. And there are some other states that also have some caveats on when you can intervene. But the worker can't intervene into a carrier suit in Alabama. The carrier has a lien. Again, remember the found money myth. Because you have a lien does not mean you're going to one day wake up and there's a check in the mail for the full amount of your lien. Not only do you have to worry about the plaintiff's lawyers who get the same emails I do every day from the AAJ, finding unique and innovative ways of screwing you out of your money, but you're also going to be in a situation where you're going to not be able to protect your credit. We're going to talk about protecting credits toward the end of this session, because in many cases that's more important than the lien itself. Illinois, and this is one state where the credit comes into play, you have a partial simultaneous right to file suit. The employee can file suit anytime within the first 2-year statute of limitations. The carrier can sue 3 months before the statute of limitations runs. The carrier may intervene, and the carrier has a lien. But as we'll find out, Illinois is very complicated because the employer can and almost always is brought in based on some spurious allegation of negligence, and the employer can be held liable for contribution in a suit filed by the defendants. Now, Illinois allows for a Kentucky cap, which is simply a way of saying that they're not going to be liable for any more than their current lien and credit. But that Kentucky cap can be waived, and in most situations today, unfortunately, it is waived. A whole other subject that we get into in the advanced workers' compensation subrogation seminar, which will probably be offered coming up soon, and that's WC 201 on our website. Now, that was number one. Number two is which third parties can be sued. This is a significant question to be answered. If you do recognize subrogation and you do answer question number one, you've got to understand and ask yourself and answer correctly which third parties can be sued. Recognizing the liability of the third-party tortfeasor, as we mentioned, is a key to maximizing subrogation recoveries. It can be as simple as negligence. Somebody rear-ended somebody else. They didn't violate a statute. They didn't make a defective product. They simply were at fault by failing to apply their brakes on time. That's simple negligence. But medical malpractice can also be a potential third-party for workers' compensation subrogation rights in a number of states. And if the chart, which we handed out, again, if you need these handouts and you don't have them, don't worry. Jamie will get them to you. But the 1, 2, 3, 4, 5, 6th column in that chart is med-mal as 3P. In other words, is medical malpractice a legitimate third party? You can see that in Alabama, Alaska, Arizona, it is. In Arkansas, it's undecided. In California, it isn't. And it ends up being a predominantly yes. The majority of states do allow medical malpractice to be a third party, but a number of states, like California, have special tort reform caveats on that. For example, in California, you cannot take a credit on a medical malpractice recovery. So these things all get factored into that question, those questions you answer up front as to whether or not your claim would be cost-effective to pursue, and what route do you want to take to pursue it. Premises liability, products liability, obviously good potential third-party tortfeasors in those situations. Now, premises liability we'll talk about in a minute, slip and fall cases, difficult cases. Questions need to be answered. Are you in a state that is pure contrib? In other words, a 1% negligence on the plaintiff bars the plaintiff from recovering, and there are 5 states which are pure contrib: Alabama, Maryland, North Carolina, Virginia, and the District of Columbia all hold that if you have 1% negligence, you cannot recover. Those issues have to be taken into account when you subrogate, because premises cases are difficult enough, and if you have someone that trips over his own feet walking down some stairs, and you are in Virginia, for example, you want to be very careful not to invest too much money in a premises case where clearly the jury is going to put more than 1% on the injured worker. Who can be sued? Can you sue a co-employee? Can you sue the UM or UIM carrier? It is different in every state, and unfortunately, even in some states, it's different from day to day. I was successful in handling the case in Texas, which allowed for the first time a workers' compensation carrier to subrogate against a UIM carrier. I practiced in Texas for 20 years. That law has now changed to where you can only recover if the carrier is the insurer for the employer, not the employee. Negligent doctors, and the exclusive remedy rule, again, in Illinois, can the employer be sued for contribution? I'm going to go through very quickly. This is just a little teaser of some of the things that will be covered in the Recognizing Subrogation seminar when it is offered, or if you desire to have something like that offered for your company. An automobile accident, we're all familiar with these, and we become experts because we all drive. We're experts because even on the liability side, we understand the rules of the road, and it's pretty much common sense. If somebody fails to maintain a proper lookout, fails to yield, or makes an improper turn, those become pretty clear-cut. We become pretty good at subrogation when we're handling auto accidents and plain Jane vanilla fender benders. But what if you are subrogating and your claimant, who's going to work at 6 o'clock in the morning before sunrise, drives at 65 miles an hour into the back of a cement mixer who's traveling at 20 miles an hour on a freeway? Well, I handled a case like that, and of course the client said, well, there's no subrogation here. We ran into the back of a cement mixer the size of a semi. How could we possibly subrogate? Well, as it turned out, we made a nice recovery in that case because through investigation, we're going to talk about investigation in about 15 minutes, through investigation and proper sleuthing, we determined that, you know what, this truck had been on the road for 650 feet. It had not gotten out of first gear. The 2.5-inch diameter tail lights on the back were covered with dried cement. There were no street lights. There was no way this truck could have been visible to the driver until he came within the purview of his headlights, and at that point he did try to apply the brakes and slammed into the back and was severely injured. So we made a recovery for a claimant who rear-ended a cement truck. Now, why do I say this? I'm not advocating prosecuting third-party cases with frivolous facts, but I am advocating strongly being creative in creating third-party liability and recognizing it and then pursuing it. General negligence examples, I'm not going to spend too much time on this. We get into a lot more of this during the recognition seminar, but it's important for you to consider all of these things: mud covering the taillights, a sudden stop, cattle on the road, lights on, turn signals on. We all know how to investigate auto losses, but be creative when you do so. Medical malpractice, what's significant here is that you may have somebody who's recovering from a work-related injury. You think they're about to reach MMI and go back to work, and suddenly they have this horrible addiction to some painkillers, or they've bled into their brain and had heparin-induced thrombocytopenia, or they had other complications. When that happens, the knee-jerk reaction of my clients is they keep paying. Well, okay, you have to pay. If a medical condition is caused by or exacerbates a pre-existing condition, I mean, it is compensable. But what happens here is that a non-subrogable claim, a claim where he lifted something heavy and there's no third-party potential, could become a subrogation claim if there's medical negligence involved. One of the things we do is we have a staff of doctors who we have around the country, because medical malpractice is geographically sensitive, who will help us review medical records, give us an opinion that there's medical negligence, and give us the ability to go out and subrogate against a doctor who, or a hospital, or a healthcare provider who malpracticed and whose negligence resulted in our paying significant dollars above and beyond what we otherwise would have had to pay. And the important thing here is that we cannot always subrogate for the entire claim. Usually it's from the date of the medical malpractice forward. And I often argue that we should also be able to recover the surgery and the hospital bills in which the medical malpractice occurred. But these are difficult cases often, and they can be expensive cases, so they have to be looked at carefully. And there's a couple examples, and I actually am going to skip the examples because there are some things that I want to stress later on. Premises liability, again, we're going to go through this sort of thing a lot more in future seminars when we do the first-year law school torts class for you called Recognizing Subrogation. You have trespassers, you have licensees, and you have invitees. By far, I would say without a doubt, the number one type of claim we all see: someone slipped and fell, someone tripped down the stairs, someone tripped over a mat, someone stepped in a manhole, someone fell through the ceiling joists. These premises liability cases can be good, but they can also be quite difficult. Nowadays, juries are looking with a jaundiced eye toward people bringing claims unless they're seriously hurt. So premises cases have to be looked at carefully. But if investigation is done right, a simple slip and fall on a rubber mat, for example, normally would bring to mind, well, didn't he see the mat? But in certain cases, there may be mats that are not necessarily, don't necessarily work well with the conditions on the certain surface that they're on. The coefficient of friction is off, and we've had good recoveries in cases in which it looked simply like the employee was at fault. Excuse me, that was a drink of water. So ask yourself questions when you're looking at these slip and fall cases. Are there stairs up to code? Are they uneven? Tread, no railing, lighting issues. Folks, we got to take photographs. A premises liability case it's imperative that we get some indication of what happened. If somebody slipped and fell on a icy sidewalk because someone didn't shovel it in a municipality where the ordinance requires them to shovel it, ask them, please have a family member go out that day. I know you're hurting and you got to have surgery coming up, but somebody go out and take a photograph of the conditions. If you can, have an investigator do it. If you need an expert, if the claim is going to be big enough, have them get out right away, because it's important to capture, preserve, and commemorate the conditions as they existed at the time of the injury. Products liability. This is a much litigated area in subrogation, but it's often overlooked. It's often overlooked because we tend to focus and stress what the employee did wrong rather than what the manufacturer did wrong. In the late 1970s in law school, I was an idealist. I went to law school saying, I'm going to help the environment and I'm going to go out and volunteer my time and do pro bono work because I'm so fortunate to have gotten to law school. And the minute I got out and saw my law school tuition, student loan total, I went to the highest bidder. And the highest bidder at that time was a plaintiff's firm. You may know the name John O'Quinn. He is associated with the law firm named Benton Musselwhite in Houston, Texas. And unfortunately, John died tragically this past fall, but he was probably the best trial lawyer who ever lived. And I say that, he was on the cover of Forbes magazine twice. He had more $100 million verdicts than any lawyer on earth. He represented several states in the tobacco litigation. Didn't have the most untarnished reputation, but he was a thorough preparationist. He taught me how to try a lawsuit and how to prepare so thoroughly that the other side simply has to pay you. And I've carried those skills over and taught the lawyers that work with me those skills, the paramount skills of effectively looking into subrogation. So when it comes to product liability, back in law school I said, how fair is it to make a product manufacturer responsible just because it wasn't the most state-of-the-art product, or it didn't have the right warning, or the warning wasn't in the right language or in the right place, or it didn't totally explain what would happen if somebody didn't buckle their seatbelt on the forklift or set this heater up and didn't turn it off until the building had burnt down. Understand that society has given us a situation where plaintiffs' attorneys are taking advantage of something called enterprise liability. This is difficult stuff. This is stuff of principle here, but your insurance, the insurance company you work for, the clients you represent, the folks for whom you subrogate, expect you to, if at all possible, recover your dollars. And that's our mentality, and that ought to be your mentality. So when you have a products liability situation, often an expert is needed. There are some investigative costs up front, but remember the investment principle. Subrogation is an incredible investment. You must hire an expert if it's most likely a design defect. You should get the product, get statements, and be concerned about spoliation. What that means is whatever you know to be the problem, whatever product started the fire, whatever product took off someone's legs or hands or killed somebody or mangled somebody, that product must be preserved, and the manufacturer, the people who did repairs on it, as well as the people of anybody who had anything to do with the scene, must be given an opportunity to investigate and thoroughly determine for themselves if they were at fault. If not, what's going to happen is, it happens in every fire case, that the toaster oven, the Black & Decker toaster oven, may have started the fire, but I guarantee you the outlet, the wiring, the coffee maker, the can opener, the toaster, everything is going to be blamed for this fire except the thing that actually caused it. And they will each have experts saying, no, it was something else, it wasn't your product. So spoliation not only prevents them from getting an extraordinary defense in a product's case, but it also helps you prove up your case. So very briefly, 3 different kinds of product liability that you look for: manufacturing defect, design defect, and marketing defect. Again, I'm going to skip over some of this because I want to focus a little more on some of the things that are coming up. Investigation. Why is it important for you to investigate? This may be the only chance you have to get evidence. It's counterintuitive, as I said. You've got your claims hat on, a claim comes in, oh crap, it looks like someone else is at fault. What can I do? You've got to take off the claims hat and put on the subrogation hat, and you've got 20 more claims to get to. You've got statuses to update. You've got to talk to doctors. You've got to get checks out. But remember, this is an investment, and investigation and recognition and prompt pursuit of recognition, if you recall, are so important that investigation should be given real priority. You catch witnesses when their memories are fresh. You identify and retain evidence. Subrogation is actually a PR product. Those of you with large blue-chip clients, I'm often asked to go, I fly out and talk to Continental Airlines or Walgreens or McDonald's and explain why we are taking the processes and the extraordinary steps we are to get their money back, how it affects their loss modifier, their risk modifier, their loss ratio, how it's going to help them with future premiums. Suddenly you look like the superstar. Not only do you competently and conservatively adjust a claim, but you also do everything you can to make that claim go away on their loss history as though it never happened. So investigation is key. Investigation is also on-the-job training for subrogation and claims personnel. It's a walkthrough of your third-party lawsuit. It locks witnesses into positions and testimony, and guess what? It's valuable. You create a commodity that can be sold for your lien. What do I mean by that? If you investigate a case correctly, and I'm hired by clients all the time, I go in, I hire an expert, I preserve evidence, I send out notice, I have an inspection, I corral the evidence, I secure it, I secure the expert's testimony, and then I take that product, and lo and behold, a month later, a plaintiff's attorney is located in the TV guide and called and retained, and he calls me and says, I understand you have a lien, and I say I have a lot more than that. I have everything you need, from experts to photographs to statements, and I'll give it all to you in exchange for one thing. You stipulate that my client gets all their money back, and that you are not going to claim a fee off their lien. You are not going to try and defeat it, and it works like a charm. Sometimes we throw in, we'll help with experts' costs as long as we get that money back off the top. In the right case, this is a better bet than you can make anywhere in Vegas. It's better than any financial investment you can make. It's important to give notice to parties and government entities. I want to tell you a quick story. Why investigation is so important. It's an old allegory, but there are 2 nomads wandering in the desert somewhere in the Middle East years ago. They parked their camels and they set up their tents and they're just about to go to sleep when suddenly a bright light appears out of the sky. And a deep voice, a deity, talks down to them, and they scramble out of their tents and they're shaking and they look up, and the voice says, I want you to do 2 things. I want you to right now collect pebbles, all the pebbles you can, and put them in your saddlebags. And then tomorrow, at the end of your day's journey, I want you to look in your saddlebags when you set up camp. And you will be both glad and sad. And the nomads looked at each other and said, what the heck? What is that? Here I thought we were going to have some divine revelation. It's going to give us the key to happiness, the key to success. And instead he tells us to put some pebbles in our stupid saddlebags. So they do. And they sort of half-heartedly throw a few pebbles in their saddlebags, go to bed, and they travel all day. And when it comes time to camp the following night, they pull the saddlebags off and look inside, and each of the pebbles has turned into a brilliant diamond. And instantly they were both glad and sad. They were glad that they had taken the time to pick up a few pebbles, but they were extremely sad that they hadn't stuffed their saddlebags full of pebbles. The moral of the story is that investigation can be tedious, it can be time-consuming, but the value of the pebbles that you pick up when investigating may not be known until years down the road. And I can't tell you the innumerable examples I have of important investigation done by the workers' compensation carrier or the property carrier or the health insurer or the plan, but in this case workers' compensation carrier, that resulted in successful third-party litigation. It's absolutely amazing. So what are we talking about? Well, I mean, some of it goes without a need for explanation. You look into the facts. This can be a defense to combat claims for attorney's fees. We've talked about some of this. You uncover third parties and sources of recoveries. And down below in the large font, we have a separate seminar entitled, or webinar now I guess we can call it, Subrogation Investigation of Workers' Compensation Claims, filled with tips, sample investigative charts, checklists, and techniques to use. And you can use these techniques too. If you do the investigation, especially in a small claim, plaintiff's attorneys who suddenly appear on the picture may be willing to trade with you a promise to reimburse your lien in exchange for that information. But understand one thing, they can force you to give it to them unless you protect it with work product. The best way to do that is to put a memo in your file the minute you recognize subrogation that says, I recognize subrogation. I'm going to do investigation. Everything I do from this point out is going to be done, quote, in anticipation of future litigation. If you put that in your file, and later on the plaintiff's attorney tries to steal this investigation from you and you think it's valuable, and you give it to me, I can use that memo to protect your work product. Now, third-party liability, we've asked who can be sued. Can an employee sue a co-employee? Depends on the state. Again, your chart will give you some information on that. Our book goes into much detail on that. Negligent doctors. What about negligent lawyers? Well, I said earlier that medical malpractice cases make good third-party cases. A negligent lawyer, on the other hand, the minority of states allow legal malpractice as a third-party action. The reason being, you, the workers' compensation carrier, do not have an attorney-client relationship with the lawyer. Ergo, there is no duty that the lawyer has breached for which you can sue him. There are a few states that do allow it, however. Let's take a look at Utah's statute. The employer is immune. A co-employee is immune. Again, we're in that question, who can we sue? A carrier is not subrogated to UM recovery. They are not subrogated to legal malpractice, but the carrier is subrogated in a medical malpractice situation. Utah has a number of quirks on its own, including a 40% rule regarding employer negligence. That rule alone, in my opinion, on any case in which there's any substantial money to be recovered or a significant credit, mandates that you get counsel involved. Again, I promise I'm not going to peddle myself or do a commercial for referring files to us, but I'm just telling you that there are some states in which you run significant risks, because I can promise you that in Utah the trial lawyers know if you're not represented, they're going to settle their case and go to the court, and the employer's going to come in, or the defendant's going to come in, and they're going to present evidence that the employer was 60, 70% at fault, and the judge is going to go along with them, and then your lien is going to be reduced or eliminated. So that's just an example of some of the issues that we can have. Indiana, who can be sued? Employers and co-employee are both immune, even if the act is intentional. Usually intentional acts are an exception to the employer and co-employee immunity. The carrier is subrogated in Indiana to a UM/UIM policy monies, and it is subrogated to medical malpractice. It is undecided in Indiana if a carrier is subrogated to a legal malpractice action. There are several areas where I say undecided. Why is that? Do people not care? Well, understand how laws are made. Yes, it's like sausage, but nothing gets put into the sausage grinder. There is no case to take up to a court of appeals to decide whether a carrier is subrogated in a legal malpractice case unless some carrier, some subrogated entity somewhere decides they want to take that stand. One second. All right, another glass of water. So now we get to the third question, which is often the most significant question, and that is, how much money do I get? How is the third-party recovery allocated? Again, you must know the answers to maximize your subrogation recovery. What part of the settlement does the carrier receive? How and when does it recover its lien? Does the carrier recover past and future payments, as in some states, or does it get its lien back and simply a credit? It makes a tremendous difference as to how you approach a case, depending on what the state law is. Is there a special formula used? Yes, in Wisconsin, for example. In Minnesota, there are special formulas that are followed and almost never deviated from. We'll talk about those briefly in a second. Does the employer negligence reduce the recovery? Does the made whole doctrine apply like it does in Georgia? And there are a number of states now that talk about equitable distribution and equitable considerations, and they have other euphemisms for applying the made whole doctrine, which never should be applied to workers' compensation subrogation, and we get back to the social pact that I talked about earlier in the seminar. Are you subrogated to all elements of damages? Here's an area where you will almost always get screwed if a state allows you only to subrogate to elements of damages which reflect the benefits you have paid. Lost wages, past and future, medical expenses, past and future. Those economic damages, many states say you're subrogated only to those economic damages. So what does a plaintiff's attorney do when you're out there with the found money myth and you're relying on him and the fact that you have a lien? Well, he will gerrymander a settlement and allocate many of the proceeds of the recovery to people, to elements of damages rather, such as pain and suffering, mental anguish, physical disfigurement, loss of consortium. The wife gets half the money. The worker doesn't get hardly any, and what he does get, none of it represents medical expenses and lost wages. Suddenly you are playing catch-up. Suddenly you have to instantly get involved, convince the court that this is a ruse and that all the plaintiff's attorney is trying to do is gerrymander the settlement around your rights to make a recovery. So other things to consider when making that decision, do you get counsel involved or not? Look at Arizona. Arizona allows a lien on any recovery actually collectible, and this even extends to loss of consortium recovery. If I'm hurt here at work giving this dangerous webinar, and to the degree where I can't perform my husbandly duties at home, my wife, I can't take out the garbage, I can't do any of the things. My wife has a loss of care, counsel, affection, solace, and sexual relations. By the way, those always make very interesting depositions. But she has a claim because I am injured, because she is my wife. And plaintiff's attorneys constantly end up allocating huge portions of recoveries to the wife, which end up providing us not only with less money to compensate us for our subrogated lien and our right of reimbursement, but also devastate our right to a future credit. In Arizona, the carrier's lien is reduced by a proportionate share of employer's negligence. In any state where you have a lien reduced by employer's negligence, it's important to have somebody watching over the third-party lawsuit to make sure that they're not setting up a kangaroo court whereby they're going to dump on the employer, settle the case, and reduce or eliminate your lien based on the percentage of an employer's negligence. California is a classic example I'll talk about them in a minute. But in California, you basically only have three options. When you're subrogating in California, you can file a notice of lien. That's fine. But there are three ways that you can proceed. You can settle and do get your lien reimbursed and do a C&R, compromise and release. And what that means is that the comp case is closed and you may reduce your lien a little bit, or you can settle for the lien and take a future credit, which means you're going to get more of your lien back, but that credit may get exhausted, so you may have to kick in later on down the road. Or you can simply not agree to anything, in which case you're going to try basically a lawsuit dealing with employer negligence. I digress here, but my point is that these are all factors that must be taken into consideration based on each state's law. Now in Georgia, the made-whole doctrine is codified. We're talking about how much money you get back now. If the plaintiff is contributorily negligent, he's horribly negligent in causing his own injuries, 60, 70, 80%, so they have to settle the lawsuit for nuisance value. The plaintiff is clearly not made whole, and the fact that he was contributorily negligent doesn't matter. But all is not lost in Georgia. Georgia is a difficult state. If you have Georgia cases, if you are interested, I have a treatise which is entitled Georgia Workers' Compensation Subrogation Primer. It is 15 pages of thorough recommended practices and strategies in Georgia. It has a primer on the law so that plaintiff's attorneys can't bamboozle you on that. And but the good news is that you can obtain a court hearing. The burden of proof is on you. It's a difficult burden, but you can request a special verdict as well. In Wisconsin, we have something called Rimes hearings, in which the court determines if a worker, not a worker, but in other subrogation areas, if he's made whole. These court hearings in Georgia are just like the Rimes hearings in Wisconsin, and the truth is, nobody wants to go to them. So if you let the hair up on your, if you intimidate and rattle your sabers and say we're going to a hearing, and take them to the mat, oftentimes you will get compromises and increased offers on your lien before the hearing, because nobody, A, knows what is going on, what the burden is, or how these things function, and two, they don't want to take the time. Iowa, there's no contribution. Subrogated party must be made a party. Lien rights extend to benefits payable in the future, not just reimbursement for past benefits. I want to tell you that Iowa has another statute. I think it's 8555. I'm not sure. But there's a statute there that says that if you settle a contested comp claim, you waive your lien. So just know that in Iowa, if everything is contained within Iowa, be cognizant of the fact that you want to preserve your rights of recovery when settling a work comp case, even if you're not at all involved in subrogation. Now, I want to give you a couple examples of how workers' compensation subrogation works. And again, we're talking about allocation. A carrier has a $10,000 lien, $20,000 reserves, and the third-party case settles for $90,000. Generally, what's going to happen is you find out how you do. You give yourself a report card. With a $90,000 gross third-party recovery, the plaintiff's attorney is allowed to take attorney's fees and costs off the top. I've selected $30,000 for a one-third fee. That leaves $60,000. One-third of that automatically goes to the plaintiff. That leaves $40,000 that is subject to your $10,000 lien. You get reimbursed your $10,000. There's a $30,000 net recovery. That $30,000 represents a credit. How did we do? The plaintiff recovered $50,000. You, the insurance company, got $10,000, or your client, got $10,000 in a $30,000 credit. The plaintiff's attorney made $30,000, which of course was the total of $90,000. Now, the gerrymandering I told you about, here's how it takes place. The same scenario, $90,000 gross recovery is reduced by $30,000 in attorney's fees for the plaintiff. The recovery after fees is $60,000. Automatically, the wife is given $24,000 for loss of consortium, which leaves only $36,000. We follow the rest of the formula, and if you look over to the right, now the plaintiff recovers only $26,000, but his wife recovers $24,000. So they netted the same $50,000 they did before together, But you, on the other hand, got only $10,000 back and only a $14,000 credit, whereas the plaintiff's attorney has now made $30,000. So these are ways that cases can be gerrymandered, just things to look out for. Are attorney's fees or costs owed? These are significant. This is a significant question that oftentimes you can't avoid. Now, the good news is that there are states in which you can actively participate in a case and reduce the amount of fees you owe to the plaintiff's attorney. You can ask for apportionment hearings, and the judge looks at the work that both parties did and allocates the attorney's fees accordingly. That's good if you want to try and reduce the attorney's fees you pay off your lien. There are states also, such as Wisconsin, which, believe it or not, excuse me, allow you to recover not only your past lien, not only your future credit, but also some attorney's fees and costs on top of that. What do I mean? If you are active in a case, if you have done your investigation, because your investigation and all of the prep work you do after you listen to these informative webinars and you go out and you thoroughly put as many pebbles as you can into your saddlebag, you have the right to ask the court to award you fees which should have gone to the plaintiff's attorney. That means that the plaintiff's attorney, who was on a 40% contingent fee, is now looking at the prospect of giving some of his fee away to an insurance company. And you want to talk about something that makes a plaintiff's lawyer angry, it's that. And it also makes my clients proud. But we've done that in a number of cases, and there are a few states which give you that option. So again, these are some factors that we look at. There are a couple examples here of some state statutes. Just briefly, in Arizona, by the way, no attorney's fees are allowed. In Arkansas, the carrier must pay the reasonable cost of collection and must intervene or risk losing the entire lien. In California, the court can apportion. There's one of those apportioning states. In Tennessee, if active participation is there, then fees are apportioned. In Wisconsin, the formula is followed, as we just showed you in the previous example. No additional fees are owed. So basically, in Wisconsin, you do not pay a fee, which is great. And you can make a 100% recovery in Wisconsin. The only bad thing is you do have to intervene into the suit. And if you're brought in as a subrogated defendant, you have to file a subrogated cross-claim and counterclaim. Not a problem. Some states continued. Iowa, pro rata fees are owed. Indiana, pro rata fees. But Indiana, by the way, is among the minority of states that requires a carrier to contribute a pro rata share of attorney's fees, not only past benefits, but also the entire amount of future benefits. So we can be talking about a lot of money when we're talking about fees. Quick example here of fees recovered by a carrier in Wisconsin. $90,000 gross recovery. We're using the same example. Attorney's fees are taken off the top, but in this case, because we were active in the case or because you did a good job investigating, we get $10,000 of the plaintiff's attorney's $30,000 fees. I won't say who, but there's a law firm here in this state, in Wisconsin, that does not hold us in high regard because some of the fees that should have gone to their law firm to pay their overhead and pay for their Ferraris and things of that nature have gone to my clients. And that's the way I like it. So $60,000 was net. A third of that, according to the formula in Wisconsin, goes to the plaintiff. $40,000 is left over. You get reimbursed out of that $10,000. It leaves $30,000. So there's a net recovery to the plaintiff, which is also your credit. How's our report card on this? The plaintiff recovers $50,000. The insurance company $20,000 lien plus $30,000 credit. The plaintiff's attorney recovers. I'm sorry, it's $20,000 the insurance company recovers. That's $10,000 lien and $10,000 in fees. So you net $50 total, $20,000, $10 more than you paid, and $30,000 credit. And I do have clients who call me and say, I got this check, Gary. I'm not quite sure what to do with it. We don't have an accounting code that handles excess money, which is a problem I love to give them. The plaintiff's attorney recovers $20,000. That's the total of $90,000. So that was number 4, our attorney's fees and costs owed. Now remember that this seminar is an overview of workers' compensation subrogation, for every question here, for every subcategory we've gone into, there is a great deal of depth that can be gone into, not just generally, but applying the laws of all 50 states. And because we do have a body of actually 51 states, if you include the District of Columbia, it's incumbent upon us to be familiar with the laws of all those states. The chart you have in front of you, or that you will have, which is part of the handouts, is a good first start. But I even hesitated some years ago when we did this whether to put that chart together because it's deceptively simple, just like workers' compensation subrogation itself. As you're finding out, it's not all that simple. But again, remember, you boil it down to the very simple basics of early recognition of subrogation, prompt action on subrogation, and aggressive and cost-effective pursuit of subrogation. Those three principles are simple. The law may be complicated, but we have to, all of us, take off our claims adjusting hat and put on our subrogation hat, which requires us to be plaintiff's attorneys. Interesting story, real quick. And by the way, this is generally, if you're getting the gist of this, and those of you who've been at it for a while already know this, this is a horse race. This is a duel, a one-on-one mixed martial arts cage match between the insurance company and the trial lawyers. They are going to try and screw you. You are going to try and recover your lien, and somehow you both can't win. There's a story told about two lawyers walking in the woods one day, both backpacking, when this grizzly bear jumps out in front of them, 9 feet tall, claws slashing through the air. Both lawyers stare and are just scared to death. One of the lawyers drops to the ground instantly, whips off his knapsack, and starts changing out of his hiking boots and into his tennis shoes. The other lawyer looks at him and goes, "My God, what are you doing? Everybody knows you can't outrun a grizzly bear." And the last lawyer, who was just finishing tying up his shoes, said, "You fool, don't you know that the only thing I have to outrun is you?" And that is the adage for our approach on workers' compensation subrogation from day one, from the moment the first report of injury comes in, from the moment you suspect third-party liability, from the moment you click send on the letter, on the question you send to me saying, "I've got a guy who stuck his hand in a punch press and he no longer has a hand. Is he just dumb, or do we have third-party rights here?" From the moment you take those steps, this becomes a duel. It becomes a race to the courthouse. And the simple truth is we don't have to be fast. We just have to be faster than the plaintiff's lawyer is, and you will maximize your subrogation recovery. So now we're looking at, actually, getting back to the previous slide, we're getting to the last question of the 5 sub-questions that we have to ask for every claim. Do we get a future credit? Again, throughout this seminar, we're not getting into the nuts and bolts of how to handle a products liability case. We didn't go into much depth on investigation, but we're giving you a framework from which to understand and work in when it comes to workers' compensation across these 51 jurisdictions. So do we get a future credit? It's number 5, but it might as well be number 1, because from day one, your primary job here is to get in and out of this case as quickly as possible, to make the loss as though it had never happened, and to give yourself a future reserve takedown such that you never, ever again have to work on this claim. Not only is it good for you, because your employees can go and work on other claims, but it's also good for the employer. It's also good for the insured, because it affects his risk modifier and can help him in the future with reduced premiums. So let's look at the statutory credit. Often, the third-party suit settles prior to the workers' compensation, claim settling. That's not often the case. But where that is the case, we have situations where one department may want to subrogate and make a nice recovery of a past lien, get a future credit, And the other folks who are adjusting the claim are telling you, look, we've got a significant reserves here. It's coming up to year end. I want to take this reserve down. I want to waive the lien and close out the comp case. Somebody on the other side is doing the math. A plaintiff's lawyer on the other side is calculating what he thinks he could recover at the commission level, what he thinks the claim is worth, whether he can settle it. He's selfishly asking how much in fees he can recover. You need to be doing the math as well, because if you have a good third-party case and an open workers' compensation claim, don't forget, you recover your past lien, but you also get a future credit for any net recovery the worker recovers. Again, depending on the state, there are variations. That future credit means that you will be able to take a vacation on paying any future benefits. There are often complicated scenarios that must be analyzed and a lot of math that should be performed when determining whether you want to waive your workers' compensation lien in exchange for simply closing out your future comp claim. I've had a number of catastrophic losses where a 25-year-old individual with a life expectancy of maybe 15 years, given his injuries, is treating heavily, but a third-party recovery would give us a huge future credit. In those situations, I have clients who instinctively want to waive the lien in order to close out the comp case. It may be the best thing to do. It might not be the best thing to do. Frequently, you are basically you're taking the risk that the worker will die at some point before you that future credit would have benefited you. In other words, if he dies the day after you waive the lien and close out the comp case, you've really screwed yourself because you were not able to recover that huge comp lien, and you closed out a comp case which only gave you a few days of relief. On the other hand, had you taken the future credit, that credit, given future treatment levels and indemnity, whatever the claim might be worth, could last you 40 or 50 years, barring any sudden unforeseen complications. So there is some risk involved, but generally the risk is minimal. And don't forget, when you take a credit, that means the worker has the money in his pocket. It also means that he is going to loathe having optional surgeries, going in for unnecessary medical treatment. He's going to probably say goodbye to his chiropractor or the pain management group because he's going to have to pay for it out of his pocket. And what's significant is when you get a future credit, somebody has to keep track of it. The burden in almost every state is on the worker. If he comes back and says, hey, guess what? I did settle this third-party case. I know you got this credit, but I'm out of money, and I need you to, again, start paying benefits. Well, the law is generally that he has to prove that all of that money went for compensable medical treatment, and it never, ever is. In 27 years handling thousands of files, I have seen 3 that I recall in which the plaintiff came back and said, we want to reopen the comp case, and in none of those cases did the carrier have to pay future benefits because they could not prove that all of the money went for compensable medical or would have been used up for compensable indemnity payments under the laws of that state. So the other thing I wanted to mention is that in 27 years of doing this, the 5 largest subrogation recoveries I have ever had, 3 were property and 2 were actually comp because we represented the injured worker and had a stipulation, were 8-figure recoveries. But what's interesting about those 5 recoveries, and I kid you not, that in all 5, the files were marked no subrogation. The 3 property cases were out of the London Lloyd's office, and the 2 work comp cases were down in Texas. But I think that speaks volume to the 3 rules that we talked about, number 1 of which is early recognition of subrogation. There is so much money left on the table because we don't take the time to investigate the gentleman who runs into the cement mixer or the person, the woman who sticks her hand in the punch press and it removes half her arm because we think, well, that was just stupid to do that. We have to put on our plaintiff's caps and think creatively. So getting back to the statutory credit, it's a situation where the carrier may be permitted to obtain a credit or an advance, as it's called in some states, a cushion, a holiday, an offset, in addition to recovering the past benefits. It's applied toward the future benefit payments, and it works like a deductible. Now, what's interesting is out in California, they have a particular situation where in order to get your future credit, you have to look at the employer negligence. Employer negligence is almost always alleged out in California because when you have employer negligence, you have a situation where that employer negligence can reduce your credit. There's something called the employer's credit threshold. Again, I told you that there are 3 scenarios in California. Again, you don't have to intervene in California. You can file a notice of claim, but it doesn't really do anything other than place the parties on notice. There are still countless ways in which they can get around paying you back, the easiest of which in California is simply to settle around you. And then you're stuck. And you do have the opportunity to go try your case, which involves your economic damages, your medical expenses, and your lost wages. You may have a $100,000 lien, but now you have to find a lawyer to go out and try that lawsuit. It might be a complicated products liability case. It could be an aviation case. Who knows? But it's going to be almost impossible to be prepared for a trial because they almost always settle it before trial, and the judge will not say, well, sure, I'll give you, months in which you can get up to speed. So they can settle around you in California, and if you're not prepared to try your case, you're done. So again, more factors to consider when you try to decide whether or not you want counsel, subrogation counsel, involved in your cases. But in California, again, the last of the 3 options is to simply contest. Everybody contests everything, and employer negligence is tried. And if the employer negligence is, say, 20%, and there's a $1 million recovery, 20% of $1 million is $200,000. That $200,000 becomes known as the employer's credit threshold. And that means, and this gets a little bit beyond the workers' compensation subrogation basics, but I want to illustrate something. That $200,000 means that your lien is reduced. If you have a $300,000 lien, your lien is automatically reduced by $200,000 and you only recover $100,000. If your lien is $50,000 and the employer's credit threshold is $200,000, you now have your entire lien wiped out because $200,000 is greater than $50,000. So your $50,000 lien is wiped out, and now there's $150,000 left of the employer's credit threshold, which eats into your credit. Now you can't simply stop paying benefits. You have to continue paying benefits unless and until that credit threshold is met. So benefits are continued to be paid. And when you've paid $150,000 in benefits, and it does behoove you to keep track, you can then claim your credit. And it's going to be for some amount in excess of that, depending on how much of that $1 million recovery the plaintiff took. So there's a good example. In California, again, there's no credit in medical malpractice cases because they have tort reform out there. And to obtain your credit, you almost have to always file for a workers' compensation to the Workers' Compensation Appeals Board, which has exclusive jurisdiction. Now, remember back to when I took you on the website and we went over some of the webinars. There is a webinar out there that I think would be of use to folks who have an interest in more information on the statutory credit scenario. It's WC 501. It's entitled Documenting Future Workers' Compensation Credits. And it not only goes into great detail in all 50 states on how the credit is applied, how it's obtained, what specific forms have to be filed, because if there's one thing you'll find that trial lawyers just have no knowledge of, when it comes to a credit like this, most states have some requirement. In Wisconsin, you have to file a specific form to claim your future credit. If you don't, arguably your credit is no good. To your great advantage, most trial lawyers don't know anything about that. So very few will be around to challenge your credit. And I've seen very few credits or advances challenged. But who wants the risk? It's very simple to follow the administrative regs, the insurance code, the Workers' Compensation Act, depending on which state you're in, which details what you need to do in order to perfect that future credit. In California, you can just take your credit, but you do have to apply for it in the process. And every state is different. And what's good about that seminar, that webinar, by the way, documenting future workers' compensation credits, it comes with some materials. In fact, those materials can be provided to you if you'd like, just by checking with Jamie. But those materials go through in great detail every state's regs and explains in common sense terms what has to be done. Now, getting back to the statutory credit, here are some examples of how the differing states handle some of the different law. In Texas, you get a credit for the entire recovery by the worker. There are some folks who say you get a credit for the net recovery. What's nice is I can provide law that says to the contrary, and at least there's a question so you can debate what that credit amount is. In Florida, many of you are familiar with something called the Manfredo formula. Manfredo was a case which was tried and went up to the Florida Supreme Court some years ago, and it says when you see these cases, think about the fact that they have forgotten the social pact we made way, way back when workers' compensation started. We went over it in the beginning of this webinar. It's a three-way pact between the employee, the employer, and the workers' compensation carrier. They forget that. And so the Manfredo court, forgetting or maybe never even being cognizant of the pact that was made way back when, allows for only a percentage reduction of future benefits based on the worker's net recovery. And the Manfredo formula is also applied in calculating your lien recovery. In Georgia, there is no future credit. And by the way, be careful. We'll talk about this in a second. Time permitting, Georgia has some rules which do not allow you to subrogate at all if benefits were not paid under Georgia law. So you have a Georgia worker travels to Texas to sell something to Texas Instruments. He is hurt when he slips and falls on one of the mats we discussed earlier. He comes back home. He's treated. He receives Texas benefits because they're felt to be more advantageous for him. And for some reason, the suit is filed in Georgia. Georgia law will not allow you to subrogate if the benefits were paid under the laws of any other state other than Georgia. It makes no sense. I have taken one case up and argued that it's against the full faith and credit provisions of the U.S. Constitution, and we didn't finish that litigation. But the bottom line is that you have to watch out for Georgia for more reasons than the made whole problem. In Wisconsin, again, the formula fees off the top. 1/3 goes to the worker, and by the way, you do not get a credit for that third. It's just, here you go, worker. We care about you. We want you to have some money free and clear, even if the carrier gets the rest of the money, because the balance does go to the carrier. If any money is left, it constitutes a credit, and there is a form you need to file. Alabama, future credit formula is too complex to go into in this presentation, but both in our book and in the credit seminar, webinar, we go into the nuts and bolts of the credit. So why do I throw it up here on the screen if it's too complex? To let you know that there is that issue out there, that if the formula is too complex to go into in this presentation, you can imagine how many trial lawyers are not going to be familiar with it, and you can imagine how many clients of mine may miscalculate and may not take the appropriate credit or maybe take no credit at all. Quick story. A number of years ago, I was traveling from Houston, where I practiced for 20 years, to Dallas. I was on the Texas Taxi, Southwest Airlines, and on the plane, I happened to get one of the seats facing backwards. I was reading the Houston Chronicle business section, and the headline said, By the way, I was going to Employers Casualty Company at the time. The headline said, "Employers seized by regulators," meaning that Employers Casualty Company was no more, or might not be no more, and that they were in trouble. And I remember getting to this conference, and they had their entire, they had a conference, not a conference room, but like an auditorium on the first floor of their building, and it was packed. I was worried about nobody showing up because they'd all be out getting their resumes together. And in fact, what I saw was a group of people who were extremely eager to find out what they could do to help save their jobs. I had more questions, more attentiveness, more curiosity, more follow-up than any presentation I've ever given. And the end of the story wasn't a happy one. Eventually they were no longer around. But I think they realized some of the problems they were undergoing. During that seminar, I made a comment similar to the comments I've made here about the future credit, and I could see a bunch of puzzled faces out there. And I stopped the presentation, and I said, "I'm sorry, do we have some questions?" And a couple of people were talking, and then they looked up and they said, "Yes, are you saying that after a third-party recovery and a large recovery by the worker becomes a millionaire, we can stop paying future benefits?" And I said, "Yes." And to my surprise, they hadn't been doing that. When they had an order of the commission to pay a certain amount of benefits, they were under the impression that they had to continue paying them, and it is probably incalculable the number of dollars that they paid out that they did not have to pay out. So, bottom line is get your right to a credit in writing, and make sure to document your credit with the Workers' Compensation Commission or the court, as the case may be. I want to give you a quick word of warning. This has gone into in more detail in future webinars, but if you are mediating, if you have a work comp lien, let's say you have a $25,000 lien, and you have put the plaintiff's attorney on notice, you have done the calculations, you have decided that you did not need counsel involved, and for some reason the plaintiff's attorney hasn't been creative enough to try and take your money away from you, it's going to come down to this. Let's say there's a $100,000 recovery. You agree to take some portion of your lien from that mediation. It is incumbent upon you to ask a very significant question. Because when that case settles, you are entitled to a future credit, it's important to ask when that credit begins. When you're involved in a mediation, and this has happened countless times to myself and my clients, the issue comes up, it's a multi-million-dollar recovery, there is funding involved, there is a structured settlement, there is Medicare and Medicare set-asides which have to be dealt with, which is a whole other subject. But I've got, for example, several cases right now that are 6 months waiting for CMS to come back and approve a Medicare set-aside. During that time, 6 months after the mediation, my client has been receiving and bills the plaintiff has been treating. At the time of mediation, there were bills in the pipeline for which services had been rendered, but they hadn't been paid. And I had to make clear, as you will have to make clear, at the mediation, we're settling for, let's say, $12,000 or $15,000 of our $25,000 lien, and you can do the calculation based on the state. You're entitled to a $50,000 credit based on the net recovery of the worker, or it could be $40,000. That 40, you have to make clear that, look, either every medical bill that comes across my desk from the moment I sign this mediation memorandum is going to go right off my desk and right to you, plaintiff, and you're going to pay it directly, or I'm going to pay it and get my discounted, pay my wholesale according to the schedules, and I'm going to add it to the total you owe me, so my $15,000 lien recovery is going to go up with every penny I pay on this lien until the settlement is funded. you have to make clear as to how that's going to happen. And quite often that's not done, and so you have this large period of time, especially with MSAs and Medicare now involved in these things, where you're getting all these bills in, and you're feeling obligated to pay those benefits when in fact you should have been obtaining a credit. So let's move on to something I want to touch briefly on. This subject of extraterritorial subrogation, I just want to make you aware of, because it is significant, and it comes into play even before you think about subrogation. It comes into play the moment a claim is made, and the moment you, with your claims hat on, have to determine which state's benefits are going to be paid. Oftentimes, almost always, the plaintiff, his attorney, are not going to put much thought into this. I mean, there are some states whose benefits are better than others, but I'm going to describe for you how it is that you are able to maximize your recovery even more by steering the state whose benefits are paid from one state to another. Again, we have a separate seminar on extraterritorial subrogation. It's only a 1-hour webinar, but the definition of extraterritorial subrogation is any effort to subrogate outside the boundaries of the state where benefits are being paid. We call that the enabling state. So if you have a Texas loss, you have Texas benefits. Texas is the enabling state. You are primarily concerned in this area about which state's subrogation laws apply, because this becomes a significant issue. If benefits are paid in Texas and the worker travels from Texas to Oklahoma and is heard in Oklahoma and a lawsuit is filed in that state, what happens? If you have 2 or more work comp subrogation statutes involved, you have to determine all of the following variables. Now, this sounds complicated, but it becomes intuitive if you think of why we're doing this. Where was the claimant hired? Where will the claimant file his claim? Where was the claimant injured? Where is the employer principally located? Where is the third-party lawsuit filed? And where is the defendant, the tortfeasor, located? The reason these 6 questions are so important is because the answers to these questions will determine the subrogation law that will apply to your recovery. So if you have more than 2 or more workers' compensation subrogation statutes involved, in other words, Texas benefits, Oklahoma injury, you could even have Louisiana employer. You could even have the plaintiff living in New Mexico. So you could have 4 different states involved. And under the facts of your lawsuit, you may want to sue the employer. You may want to sue, remember how we talked about suing for medical malpractice or for legal malpractice? One of those states might allow it, the other 3 might not. So you want to get the state with the best possible subrogation law applying to your case. So again, these 4 steps: determine the variables, determine the subrogation law of both states. If there is a conflict, for example, one state, Georgia, requires that you be made whole, Texas does not, it's clear that you will want Texas law to apply, and there is a conflict. There's a difference in the law results in the 2 outcomes. Therefore, if there's a conflict, what the law will do is they will look at applying the conflict rule of this forum state. So in our example, Texas employee travels to Oklahoma, lawsuit filed in Oklahoma. Again, we're thinking all about this all the way back to when the first report is filed. Understand that Oklahoma law has a specific conflict of law rule. Every state has a conflict of law rule, and they're one of these 4. Number 1, for those of you who have taken Latin, lex loci delecti, the place of the wrong. You apply the law of the forum state. So if Oklahoma was a lex loci delecti state, they would apply their workers' compensation subrogation statute. The Larson rule applies the law of enabling states, and there's a most significant contacts rule, and there's a lex fori, which is rare. Now I'm going to go through a couple of things here. I'm going to skip this example for purposes of time, and because I promised I was just going to make you cognizant of this. But it's important to know the laws of the state in which you're subrogating. When you have a claim and you think it's going to be a big loss, it should behoove you to send us one of those questionnaires through our website. Say, hey, I've got a Texas loss, I've got an Oklahoma injury, Texas benefits. Which state is better for me? I'll tell you, this happens a lot in Indiana and Illinois. Chicago folks working over in Indiana and the injuries in Indiana, I will tell them, look, you want to avoid, in this case, you want to avoid the Indiana statute because of the Indiana lien reduction statute that's there. We want to apply Illinois law so they can steer toward Illinois law applying. I can also steer this later on, but the practical tips here are that, remember to determine if more than one state's law applies and always assert your future credit. Now, this concludes the seminar, and I'm going to stay around to answer some questions that you might have. I'm not sure how effective that's going to be, but remember, if you need to run and grab some food, you can send your questions via that mechanism I showed you on the website. I want to thank you for attending. One quick story. Unless you educate yourselves on subrogation, as we are doing, and this is the first, this is the tip of the iceberg, you cannot have an effective subrogation program. And that applies whether you are an insurance company, a TPA, or even a law firm. You have to know the nuts and bolts of this stuff. There was a burglar who once went into a house and he was going to burglar it, and he's walking along and he's in the dark with his flashlight on, and all of a sudden, through the darkness, pierces this voice, a real high-pitched voice. Jesus is watching. And the burglar stopped cold in his tracks, trembling. Oh, my God, I've been discovered. And he waited and waited and heard nothing more, so he flipped on his flashlight again and started tiptoeing, and he heard it again. Jesus is watching. And he flipped his flashlight around, and there, to his great relief, in the corner, he saw a cage, and in that cage was a parrot. And the parrot, of course, had been talking. So he walks up to the parrot and shines the light in the parrot's face and says, wow, am I glad it's just you. Who are you? And the parrot says, I'm Wally. He says, Wally? Well, that's a strange name for a parrot. Who in the world would name a parrot Wally? And the parrot looks at him and says, the same idiot that named the Rottweiler Jesus. And the point here is that unless you understand and you have the facts, you have no idea what you're walking into. Education is the key to subrogation, and more importantly, education is the key to protecting subrogation. So I'm going to click pause. We will stay around for some questions. I will be on the air to answer those questions, and if there aren't too many, we'll be getting to each of you notices of the upcoming seminars. You can see all of those seminars on our website, the place I went to with you earlier in this webinar. If you click on any of those seminars, it opens up and gives a full description of what's covered in them. By the way, also on our website, just a little bit of self-indulgence. We have our books on there. There are forms on the front page for referral of subrogation matters. If there's anything that you'd like us to help you with, we handle work on an hourly matter basis, on a contingent fee. If there's anything in Wisconsin you'd like us to handle, we handle it on a flat 25%. And we can work on blended fee arrangements. We want to please you, so if there's anything we can do for you, please let us know. And I'll be quiet now, and we'll take any questions. I don't think you're going to hear people speak. I'll have to read the questions and answer them, and I'll let you know if we have any. I'll be back in a second. Okay, now my IBM Selectric technology challenged self is going to try and call on somebody. And it's hard because we have a ton of people in this room. And I'm scrolling down through hundreds of names to find out who has their hand up. I didn't see a question mark. Robin DeMillo, Jamie said you had a question. Let me click on that. me try and unmute you. Robin?
Yes.
Hey, I've unmuted you, so now you are being heard by 516 people.
Wonderful.
How are you?
Good. How are you, Gary?
I'm doing good. What can I do for you? What's your question?
Oh, I guess you couldn't open it, huh? My question is, in Georgia, for anybody that knows Georgia workers' comp, they most often settle, and it states they're no longer in any need of medical treatment. Can you use that against them, against the made-whole doctrine?
Okay, repeat that question again. By the way, I'm trying to open it, too, as we sit here.
Okay. In Georgia, a workers' comp claim, they most often settle, and the paperwork states that they are no longer in need of medical treatment. Now, that technically doesn't make them whole. However, it gives you a good argument.
Oh, absolutely. And I mentioned earlier, Robin, in this seminar, and I will have Jamie send this to you. It's in this Georgia Workers' Compensation Subrogation Primer. It goes into exactly that. Not only can you use that, but one of the things I use are the defense experts, the defense doctors, because oftentimes, if push comes to shove, what we have to do is we have to litigate the issue of whether or not the claimant is made whole in Georgia. And to do that, basically, there's a jury. Most of the time it's done to the court. And I put on my evidence, which consists of the defendant's doctors, which I can get right from their discovery. It consists of trial lawyers who will say they've handled cases like this countless times, and never has they recovered as much as the claimant is claiming it's worth. Anything we can throw at them, at the judge, to convince him that this worker is made whole will work. And you are absolutely right that there's valuable information and tools found within the comp settlement documents themselves, and often some admissions in depositions and things that we can use to accomplish that. It's an uphill battle. I'm not going to tell anybody that Georgia is easy, because it's not, but it can be done, and we've had 2 nice recoveries in Georgia recently, and most of the time it's because the plaintiff's attorney just is not at the top of his game, so we have to be ready for that too.
Thank you.
Is that good?
That's good. Thank
okay,
you.
Cool. Anybody else? And hang on one second. Go to questions. Gotcha. I am. Oh, here. Right here? Oh, okay. Okay, good. Here we go. Robin, I've got your question here. Thank you. Ann Perkins. Thank you. Great seminar. I had to read that part. I have on occasion, I've seen when multiple states are involved, the third-party claim will be filed in federal court. How should we pursue recovery in that instance? Great question. Actually, Earl, is this Earl Cartwright's question? Or Ann's? I can't tell. Forgive me for this is some new software. But regardless of whether Earl or Ann asked the question, it's a great question. This is a super secret tool that we can use. If the third-party claim is filed in federal court, you are in the driver's seat. I don't care which state you're in, but there is the 10th, I think it's the 10th Amendment. There is an amendment to the U.S. Constitution which reserves workers' compensation claims to the state. I'd have to go back and refresh myself with the exact terms of it, but I have an article, as we always do, on that subject, and it can be found on the website under published articles or news. I think it's under newsletter, and you can basically remove that case or remand that case to state court. Now, if the plaintiff filed in federal court because he wanted to be there, you now can threaten to remove him to a jurisdiction, most normally state circuit court or state district court, where he does not want to be. And that is worth a lot of money to him. If he's in Dallas or a conservative venue, he does not want to be in state court in Dallas. He'd rather be in federal court, and sometimes even before a judge, especially if he knows the judge. So just like we could use your investigation to barter for a stipulation, we can use the threat of remanding this case back to state court. If, on the other hand, he is in federal court because he has to be in federal court, meaning we have both the plaintiff and the defendants are all from diverse citizens of different states, and we have diversity, you can then use that same law to offer to get him to remand this case to state court where he wants to be. Again, it's worth a lot of money to him, so you can almost always get away with a full recovery for a lot less than you otherwise might because of that. Let's see. I'm looking further down here. We have another question. Bear with me while I open it up. And this question is: does Pennsylvania? I got to scroll down a little further. Does Pennsylvania have a credit? Yes, Pennsylvania does have a credit, and actually the credit works very similar to how it works in other jurisdictions. Pennsylvania is a kind of a bizarre state in that there's a lot of questions about what your rights are to actually file suit. There is some disagreement about that, and I have an article on that too on the website. If you go to the newsletters and put find and type in Pennsylvania, I think it might be the only. Now, there's a couple of Pennsylvania articles, but you'll find it right away. So, yeah, the answer is yes, there is a credit. Quick question here on medical malpractice. Medical malpractice cases, how do you prove medical malpractice? Good question. It's not always easy. We have a program here whereby if you have a significant claim and you suspect malpractice, you suspect overtreatment, you suspect addiction to drugs, you expect too much heparin, too much of anything, or the pedicle screw, somehow extends through the nerve sac, or whatever the problem might be. If it's not natural and you suspect that you're paying out more money because of doctor negligence, what I will do is I have a doctor here who looks at it, looks at the medical records. We summarize the records. We have him look at the records. He gives a preliminary opinion. Then he calls a doctor in the locale where the injury happened, says, hey, I've looked at this. To me, this looks like clear malpractice. Do you concur? And the doctor, we send him the summary so he doesn't charge us a whole bunch of money looking through the records. And he will either tell us yay or nay, there's medical malpractice. Now, I've pursued medical malpractice cases and tried mid-mal cases. I don't particularly enjoy them. They are difficult, and there is a backlash in society against suing doctors. But the bottom line is that if a doctor screws up, juries will award money, and what I will do is I will take that information and see if the claimant isn't represented. If they are represented, I can offer a package to the plaintiff's attorney, which he almost always takes, and he will pursue subrogation with my package, my medical records, my medical summary, and a doctor already paid for who has looked at the records and said there's medical negligence. In exchange, I get a stipulation for your lien, and things are pretty cut and dried. So that is a good way to pursue those types of cases. And I think that's about all the questions we have. Oh, I go to chat. I'm being told to go to chat. Jamie is saying that there's somebody in chat with a question. And yes, the question: does ERISA play into workers' compensation? Good question, and we do have a book on ERISA and health insurance subrogation, and it actually, ERISA does not play into workers' subrogation directly. ERISA and health insurance in general is not primary when you have a work-related injury. There is a good article. It's nice to be able to refer back to the website. There is a good article that can be found under newsletters. And I believe it's under newsletters. If it's not there, it's under published articles. But you can I would just click ERISA, and it has to do with how the interplay there. If you have a health insurer, let's say you have a contested work comp claim, and the bills have to be paid by somebody. Many states have laws that mandate that the health insurer pay those bills, even though they're not primary. It's a work-related injury, but you may be contesting it. Maybe it's not work-related. Maybe you're arguing that there was intoxication or drugs or some other defense, or that there's a dispute over who the employer is, or a dispute among carriers. There's a law that in many states that requires the health insurer to pay, and then that health insurer has a right usually to intervene into the work comp proceeding, and if there is a favorable finding for the claimant, that health insurer gets subrogated back those benefits. But I don't think ERISA plays a role in that sort of reimbursement or in workers' compensation subrogation like it does in the area of health insurance subrogation. And okay, I got a question, actually 2 more questions here, and I'm pulling it up as we speak. I'll get better at this, folks, I promise. Getting it up. Okay, what about, here's the question. If you have an injury in one state and a lawsuit filed in the other, and one state allows recovery against a contractor and the other doesn't, which state's laws applies? Okay, I think what the question is asking is some states allow you in a construction setting. When you go back to those 5 questions we talked about, the third one, who can be a third party? Actually, that's the second question. Who can be a third party? If you're in a construction setting where many, many work-related accidents happen, we are having some problems. We're having some developments which are not favorable to subrogation. For example, Nevada, using OSIP and wrap-up policies, are holding that everybody under this wrap-up policy is considered an employer. Everybody's an implied employer. Or a statutory employer, and you can't sue them. So we're having to work around that. Or, for example, if you have a subcontractor, there are a lot of states now have laws which govern when you can and can't sue a subcontractor. So if you have an employee who's injured due to the negligence of a subcontractor, for example, in Kansas, you cannot recover. In Nebraska, you can. And there is a 10th Circuit opinion that we were responsible for, and my 52-year-old mind is struggling to think of the name of it, but basically we argued that Nebraska law would apply because Nebraska law paid the benefits. And again, remember we touched on extraterritorial subrogation. Kansas law determined which state's subrogation law applied, and Kansas law, in a questionable 10th Circuit opinion, pointed to Kansas law. So we were not able to recover in that case. But we had some significant settlement offers on the table in a state where we should not have been able to recover. The client didn't take those settlement offers, but we ended up losing that case. So that's an example of that, and I hope that answers your questions. Texas attorney's fees. Can you recover attorney's fees in Texas? I think what is being asked is if you have a subrogation lien in Texas and you are active and you intervene into the case, can you recover money from the plaintiff's attorney? The answer is yes. There is a 1989 Texas Bar Journal article which has been cited by the Supreme Court as authority on that issue, and the author is a brilliant, handsome, absolute godlike individual. I wrote that article, and I was just pleased as punch that the Texas Supreme Court actually decided that they were going to refer to it as authority, and it goes into great detail. And it's called the lead horse theory or something like that, and you can recover attorney's fees from the plaintiff's attorney. And I'm looking, and I see no other questions, and I want to thank everybody who's left for attending. If you think of any questions, or if this seminar functioned as it was supposed to, which is when you go back to your desk and you're working on a claim and you go, aha, I think this is something that was spoken about in that webinar, get on the Matthiesen, Wickert Lehrer website, which by now will be your homepage, I'm sure, and go to the question box, send it in. I'll tell you what happens. I hate to give away what happens behind the screen here at Oz, but it comes directly to me. If I'm here, I answer it personally. If I'm not here, it's timed, and then it goes to somebody else, and there it sits, and if it's not answered within time it goes to somebody else because we do have trial schedules and things. So you usually get a question answered within the hour, almost always within the day, and you can certainly get something back quick that way. You can call, and that's fine. The only problem is I may not have the answer off the top of my head, and I know that's hard to believe. But thank you all for attending, and God bless. And I'll look forward to all of you attending the next webinar.